This is Boadu TV, truth and integrity.
We have done our own counting of the majority members. Mr. Speaker, they are 113. But, Mr. Speaker, in the interest of democracy, we haven't registered our protest. Okay. Mr. Speaker, since the majority leader has indicated that they will not listen to the views expressed, including that of organized labor, Mr. Speaker, we are leaving them. Debbie. I take responsibility. Let's go. There's no point. Mr. Speaker, the majority leader has let the cat out of the bag. He says that the door is shut. It is not only the minority that is raising issues against this bill, but organized labor has also done so. If he says they want to go ahead, Mr. Speaker, if he says they want to go ahead, and Mr. Speaker, when the majority leader speaks with all his authority, he says, today, he says he will pass. Mr. Speaker, the Constitutional Review Committee has spoken against this bill. They said they will do what they want to do. Mr. Speaker, we are Democrats. We are not going to be part of this rumble style of, Mr. Speaker, destroying the judiciary. They started by sacking the Chief Justice. After sacking the Chief Justice, they also allowed contingency fund account to be garnished. Now they want tribunal to be made up of non-lawyers, non-judges, to prosecute people. Mr. Speaker, they should do what they want to do.
On point of relevance, you are being out of order. Yes, Majority Leader.
Yeah, Mr. Speaker.
Majority Leader.
Mr. Speaker.
Honorable members, order. Honorable members, order. Honorable members.
Mr. Speaker.
For the purposes of clarity,
yeah,
let me repeat the results. The minority who voted aye were counted 16. The majority who voted no were 134. And the decision of the court in Justice Abdullahi versus Attorney General is that when the person presiding is a deputy speaker, He represents a constituency. Therefore, his vote cannot be taken away from him. I'm therefore exercising my vote to support the no, making the no 135. The total number of votes cast is 151. Honorable members, the Supreme Court's decision in the case of Justice Abdullahi versus Attorney General is now part of our Standing Order 1525. And I read, where a deputy speaker or a member is presiding, the deputy speaker or a member shall communicate his personal votes to the clerk at the table to be added to the collated results before the results of the vote are declared. So the decision of the court is captured by our own standing order. So the total vote for today is 151. Honourable members, can we make progress? Clause 5. Chairman of the committee.
Mr. Speaker, we had already taken clause 5, but let me just go over it. Amendment proposed, head note, delete tribunals and insert.
We have taken a vote on the 5 before he brought us back to 4. So we now move to clause 6.
6, yes. Mr. Speaker, rightly so.
So you may move clause 6.
Relationship between tribunals and the judicial system.
Mr. Speaker, clause 6, amendment proposed, delete tribunals and insert tribunal. I so move, Mr. Speaker.
Honourable members, the proposed amendment by the chairman of the committee is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Aye. Those against say no. Honourable members, the proposed amendment is ordered to stand part of the bill. I will then put a question on entire clause 6 in the absence of any further. Yes, chairman of the committee.
Mr. Speaker, there's a further amendment to clause 6(4). The proposed amendment is to add regional tribunals as A. So a district tribunal is bound by a decision of A, regional tribunal, the regional tribunal, the High Court, the Court of Appeal, and
I'll put a question. Those in favor say aye. Aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill, and I will direct the drafters to renumber clause 5(4). I will then put a question on the entire clause 6(4). I will then put a question on the entire clause 6. As many as are in favor say aye. Aye. Those against say no. The ayes have it. Clause 6 is ordered to stand part of the bill. Clause 7.
Composition of regional tribunal.
Speaker, amendment proposed, subclause 1, paragraph B, delete 1 and insert A. I so move, Mr. Speaker.
Yes. Honorable Chairman of the committee, have you advented your mind to Article 142B? Why are you trying to change the constitutional language? The constitutional language is as captured here. So why are you changing it? Have you seen it?
Mr. Speaker, I'm minded to avert my mind to the constitutional provision.
You are minded to.
Yeah, so I will abandon the.
Very well.
amendment.
The proposed amendment abandoned. Honourable members, I will then put a question on clause 7. As many as are in favor of clause 7 standing part of the bill say aye. Those against say no. The ayes have it. Clause 7 is ordered to stand part of the bill. Clause 8.
Qualification of members of a regional tribunal.
Chairman of the committee.
Mr. Speaker, amendment proposed, subclause 1, line 1, after with, delete clause 1 off. I so move, Mr. Speaker.
All members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman of the committee, VI.
VI, amendment proposed, Mr. Speaker, subclause 1, paragraph B, delete and insert the following. I so move.
All members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. I will then put a question on entire clause 8 in the absence of any further amendment. Those in favor say aye. Those against say no. The ayes have it. Clause 8 is ordered to stand part of the bill. Clause 9.
Composition of district tribunal.
Chairman of the committee.
Mr. Speaker, I want to abandon clause 9. It will run the same way as clause 7. I so abandon, Mr. Speaker.
Very well. I will then put a question on entire on clause 9. Those in favor say aye. Those against say no. The ayes have it. Clause 9 is ordered to stand part of the bill. Clause 10.
Qualification of members of a district tribunal.
Chairman of the committee.
Mr. Speaker, no proposed amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, honourable members, I'll put a question. Those in favor of clause 10, standing part of the bill, say aye. Those against say no. The ayes have it. Clause 10 is ordered to stand part of the bill. Clause 11.
Appointment of chairman of tribunal and panel members.
Chairman of the committee, you may move amendment VIII.
VIII, Mr. Speaker, amendment proposed, subclause 1, delete and insert the following as advertised on page 16. I so move, Mr. Speaker.
All members, the proposed amendment by the chairman of the committee is for the consideration of the House. In the absence of any further proposal, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question to entire clause 11 in the absence of any further amendment. Those in favor say aye. Those against say no. The ayes have it. Clause 11 is ordered to stand part of the bill. Chairman of the committee, you may move the new clause after clause 11.
Mr. Speaker,
As
with your permission, may I move that after clause 11, insert the following new clause as captured on page 16. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question on the new clause. Those in favor say aye. Those against say no. The ayes have it. The new clause is ordered to stand part of the bill. Clause 12.
Retirement and resignation of chairman of regional and district tribunals.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 12 is ordered to stand part of the bill. Clause 13.
Removal of chairman of tribunals and panel members.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, do you have any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 13. Those in favor say aye. Those against say no. The ayes have it. Clause 13 is ordered to stand part of the bill. Clause 14.
Code of conduct and disciplinary rules.
Chairman of the committee,
No advertised amendment.
it is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 14 is ordered to stand part of the bill. Clause 15.
General jurisdiction of tribunals.
Chairman of the committee,
Mr. Speaker, no advertised amendment.
it is for the consideration of the House. Honourable members, any proposed amendment to clause 15? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 15 is ordered to stand part of the bill. Clause 16.
Jurisdiction of regional tribunal.
Chairman of the committee,
Mr. Speaker, no advertised amendment.
it is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. Those in favor of clause 16 standing part of the bill say aye. Those against say no. The ayes have it. Clause 16 is ordered to stand part of the bill. Clause 17.
Powers of regional tribunal.
Mr. Speaker,
Chairman of the committee,
Clause 17, amendment proposed, paragraph B, line 2, delete may and insert has power to. I so move, Mr. Speaker.
it is for the consideration of the House. Honourable members, any further amendment? I'll put a question on the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 17 is ordered to stand part of the bill. Now I'll put a question on the entire clause 17. As many as are in favor say aye. Those against say no. The ayes have it. Clause 17 as amended is ordered to stand part of the bill. Clause 18.
Decisions of regional tribunal.
Chairman of the committee,
Mr. Speaker, clause 18, amendment proposed, after subclause 1, insert the following new subclause as advertised on page 17. I so move.
honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 18 is ordered to stand part of the bill. Now I'll put a question on the entire clause 18. Those in favor say aye. Those against say no. The ayes have it. Clause 18 is ordered to stand part of the bill. Clause 19.
Jurisdiction of district tribunal.
Chairman of the committee,
Mr. Speaker, no advertised amendment.
it is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 19. Those in favor say aye. Those against say no. The ayes have it. Clause 19 is ordered to stand part of the bill. Clause 20.
Powers of district tribunal.
Chairman of the committee,
Mr. Speaker, no advertised amendment.
it is for the consideration of the House. Honourable members, any amendments? Those in favor of clause 20 standing part of the bill say aye. Those against say no. The ayes have it. Clause 20 is ordered to stand part of the bill. Clause 21.
Decisions of district tribunal.
Chairman of the committee,
Mr. Speaker, clause 21, amendment proposed, after subclause 1, insert the following new subclause as advertised on page 17. I so move.
honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor of the proposed amendment standing part of the bill say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now the question is on clause 21 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 21 is ordered to stand part of the bill. Clause 22.
Concurrent jurisdiction with other courts and limitations.
Chairman of the committee,
Mr. Speaker, no advertised amendment.
it is for the consideration of the House. Honourable members, any amendment to clause 22? In the absence of any amendment, I'll put a question to clause 22. Those in favor say aye. Those against say no. The ayes have it. Clause 22 is ordered to stand part of the bill. Clause 23.
Matters excluded from the jurisdiction of a tribunal.
Chairman of the committee,
Mr. Speaker, clause 23, amendment proposed after paragraph B, insert the following new paragraph. I so move, Mr. Speaker.
honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question onto the proposal amendment. Those in favor say aye. Those against say no. Honourable members, the ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question on entire clause 23 as amended. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 23 is ordered to stand part of the bill. Clause 24.
Reference to the Supreme Court.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 24 is ordered to stand part of the bill. Clause 25.
Rules of procedure before a tribunal.
Chairman of the committee.
Mr. Speaker, clause 25, amendment proposed after subclause 1, insert the following new subclause as advertised on page 17. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? I'll put a question onto the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 25 is ordered to stand part of the bill. I'll put a question on the entire clause 25 in the absence of any further amendment. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 25 as amended is ordered to stand part of the bill. Clause 26.
Mode of trial.
Mr. Speaker,
Chairman of the committee.
no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 26? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 26 is ordered to stand part of the bill. Clause 27.
Right to legal representation.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 27 is ordered to stand part of the bill. Clause 28.
Application of Evidence Act 1975, NRCD 323.
Chairman of the committee.
Mr. Speaker, amendment proposed under 28 is to delete the entire clause. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 28 is ordered to be deleted from the bill. Clause 29.
Proceedings to be open to public.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Any honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 29 is ordered to stand part of the bill. Clause 30.
Live broadcast of public interest cases before regional tribunal.
Chairman of the case, Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 30? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 30 is ordered to stand part of the bill. Clause 31.
Restrictions on media coverage of proceedings of district tribunal.
Chairman of the committee.
Mr. Speaker, no advertised amendments.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 31? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 31 is ordered to stand part of the bill. Clause 32.
Compliance with procedural safeguards.
Chairman of the committee.
Mr. Speaker, clause 32, amendment proposed is to delete the entire clause. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? Those in favor say aye. Those against say no. The ayes have it. Clause 31 is ordered not to stand part of the bill. Should be deleted. Now, clause 32 is ordered not to be part of the bill, is deleted. And I direct the drafters in view of the deletion in 28 on 31 to check the renumbering. Clause 33.
Application of sections 34 to 42.
Chairman of the committee.
Mr. Speaker, there's no advertised amendment.
It is for the consideration of the House. Honorable members, any proposed amendment to clause 33? Honorable members, in the absence of any proposed amendment, I'll put the question. Those in favor of clause 33 standing part of the bill say aye. Those against say no. The ayes have it. Clause 33 is ordered to stand part of the bill. Clause 34.
Mode of instituting proceedings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honorable members, any proposed amendment to clause 34? In the absence of any proposed amendment, I'll put the question. Those in favor say aye. Those against say no. The ayes have it. Clause 34 is ordered to stand part of the bill. Clause 35.
Service.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honorable members, any proposed amendment to clause 35? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 35 is ordered to stand part of the bill. Clause 36. Clause 36. Clause 36.
Defense of accused person and plenary objection.
Chairman of the committee.
Mr. Speaker, no advertised amendment for this.
It is for the consideration of the House. Honorable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question. Those in favor of clause 36 standing part of the bill say aye. Those against say no. Honorable members, the ayes have it. Clause 36 is ordered to stand part of the bill. Clause 37.
Electronic service.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honorable members, any proposed amendment to clause 37? In the absence of any proposed amendment, the question is as many as are in favor of clause 37 standing part of the bill say aye. Those against say no. The ayes have it. Clause 37 is ordered to stand part of the bill. Clause 38.
Trial.
Chairman of the committee.
Mr. Speaker, clause 38, amendment proposed, subclause 4, delete and insert the following as advertised on page 18. I so move, Mr. Speaker.
Honourable members, those in favor of the proposed amendment by the chairman of the committee say aye. Those against say no. The ayes have it. The proposed amendment by the chairman of the committee is ordered to stand part of the bill. Any further amendment to clause 38? In the absence of any further amendment, I'll put a question. Those in favor of clause 38 standing part of the bill say aye. Those against say no. The ayes have it. Clause 38 is ordered to stand part of the bill. Clause 39.
Interlocutory appeals.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 39? In the absence of any proposed amendment to clause 39, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 39 is ordered to stand part of the bill. Clause 40.
Stay of proceedings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the
Clause
consideration
40.
of the House. Honourable members, any proposed amendment to clause 40? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 40 is ordered to stand part of the bill. Clause 41.
Day-to-day trial of case.
Chairman of the committee may move amendment XVIII.
Mr. Speaker, amendment XVIII, clause 41, proposes subclause 1, line 2 and 3, delete a day-to-day and insert an expeditious. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? I'll put a question to the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, you may move amendment XIX.
Mr. Speaker, XIX subclause 2, line 1, delete a day-to-day and insert an expeditious. And in line 3, delete 14 and insert 7. I so move, Mr. Speaker.
So let's take this. I'll put a question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Chairman, you may move amendment XX.
Amendment proposed XX is to delete the entire clause. I so move, Mr. Speaker.
Honourable members, any further amendment to the amendment proposed by the chairman of the committee? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. Honourable members, yes. Honourable Majority Leader.
Yeah, Mr. Speaker, I know you've passed 41 already, but
we are now on 41.
We're now on 41.
Yes.
Yeah, 41 line.
So let's finish putting the question on this before I put a question on entire clause 41. Then you can raise your issue. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill, and consequently, subclause 3 is deleted. Yes. Majority Leader.
Yeah, Mr. Speaker, if we can go back to where we try to delete day-to-day and then insert an expeditious. If you say shall proceed on an expeditious basis, proceed on an expeditious basis, I doubt if that is a proper coherent rendition, because what it says is that delete day-to-day and then leave basis, and in place of day-to-day, a day-to-day, you say an expeditious basis. That's not
so
accurate.
The rendition will be a trial commenced under the Minerals and the Mining Act 2006, Act 703, shall proceed on an expeditious basis until the conclusion of the trial, except where an expeditious trial is impracticable.
So the proper rendition should be shall proceed expeditiously. Shall proceed expeditiously until the conclusion of the trial, except where an expeditious trial is impracticable. That would be a proper rendition.
Very well. Chairman of the committee?
Mr. Speaker, I'm minded to go with
very well. Then I'll then put a question on the amendment proposed by Yes, Leader. According to the drafters, that it will be problematic. So we should leave it the way it is. Yes, Majority Leader.
Yeah, Mr. Speaker, the thinking is that the court should sit daily, because one of the issues that the whole architecture of the tribunal system is meant to deal with is adjournments. The public outcry regarding, adjournments and how that frustrates the administration of justice. So the idea is to put pressure on a panel of the tribunal to sit every single day until they dispose of the matter, except where it is impracticable for them to sit every single day until the matter is disposed of.
So if you put it that way, what happens if the court did not sit on daily basis?
Well, the idea is that the court must sit on a day-to-day basis. That's the idea informing the reform, unless it is impracticable for them to sit, assuming that it rains and the whole area is flooded and their lives are at risk if they try to get to the tribunal, building, or some other circumstance that makes it impracticable, assuming that a member of the panel suddenly falls ill and therefore they cannot, constitute a panel to try the matter. But the principle is to deal with the adjournments that have tended to frustrate the administration of justice by demanding that they sit on a day-to-day basis to hear the matter and dispose of it expeditiously, unless that is not practicable. That's the principle.
Attorney General, what do you say to this?
Right Honorable Speaker, I support the initial rendition because, as the leader has pointed out, the idea is to ensure that the long adjournments are a thing of the past when it comes to the tribunals. And I think that day-to-day or daily is a more precise concept than expeditious. So I support the initial rendition that are brought in the bill.
Chairman of the committee, what do you say?
Mr. Speaker, this we debated for some time.
That's why I was deferring to my committee.
And so on the basis of that, I am now just seeing the deletion of 3 to tie in with getting back to the old rendition or the original rendition. Where
I'll prevail on you to abandon your amendment and let's allow what is in the bill to pertain.
Mr. Speaker, except to say that XX, I now want to see the same 41.
Because your amendment will also have impact on the head note.
On which one?
On the head note.
Because the head note says day-to-day trial of cases.
Yeah. So, Mr. Speaker, I will abandon clause 41. I will abandon XVIII and XIX. We will have to debate XX then.
Very well.
After the abandonment of
Very well.
2.
Very well. So, our members, Chairman has abandoned the proposed amendment that we put a question on. But in order not to have a problem, I'll put the question on the entire clause 41. Chairman having abandoned the proposed amendment in XVII and XIV. Those in favor of clause 41 as amended standing part of the bill, say aye. Those against, say no. The ayes have it. Clause 41 as amended in XX to delete subclause 3 is ordered to stand part of the bill. Clause 42.
Adoption of proceedings.
Chairman of the committee.
Mr. Speaker, may I get you right on X?
So the only amendment carried here
is XX.
Is XX.
Brilliant. That's fine.
That's what I'm saying. Clause 41, you have abandoned XVII,
yes,
XIX. So the only amendment carried is in XX.
Very well.
That's why I use the word as amended in SX to delete subclause 3.
Noted, Mr. Speaker.
Very well. So we proceed to clause 42.
Adoption of proceedings.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 42? I'll put a question. Those in favor of clause 42 standing part of the bill say aye. Those against say no. Honourable members, the ayes have it. Clause 42 is ordered to stand part of the bill. Clause 43.
Establishment of Tribunal Oversight Committee.
Chairman of the committee.
Mr. Speaker, clause 43, amendment proposed, delete and insert the following as advertised on page 18. I so move.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, the question is as many as are in favor of the proposed amendment by the chairman of the committee say aye. Those against say no. The ayes have it. The proposed amendment to clause 43 is ordered to stand part of the bill. Now I'll put a question on clause 43 as amended. Those in favor say aye. Those against say no. Clause 43 as amended is ordered to stand part of the bill. Clause 44.
Membership of committee.
Chairman of the committee.
Speaker, XXII, clause 44, amendment proposed, subclause 1, paragraph A, delete and insert the following. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Clause 44.
XXIII, Mr. Speaker.
That is so.
Amendment proposed, subclause 1, paragraph B, subparagraph II, line 2, after justice, insert not below the rank of a deputy director. I so move, Mr. Speaker.
Honourable members, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Still on clause 44.
Speaker, rightly so. XXIV, clause 44, amendment proposed, subclause 1, paragraph B, subparagraph III, delete. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Honourable members, in the absence of any further amendment, I'll put a question. Those in favor of the deletion of subclause 1, paragraph B, II, say aye. Those against say no. The ayes have it. Subclause 1, paragraph B, subparagraph II is accordingly ordered to be deleted. Yes, Chairman, still on clause 44.
Rightly so, Mr. Speaker. XXV, clause 44, amendment proposed, subclause 1, after paragraph B, insert the following new paragraph as advertised on page 19. I so move, Mr. Speaker.
All members, the proposed amendment is for your consideration. Any further amendment to the proposed amendment? In the absence of any further amendment, I'll put a question to the proposed amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 44 is ordered to stand part of the bill. Yes, Chairman, your last amendment to clause 44.
The last one, Mr. Speaker. XVI, clause 44, amendment proposed, sub clause 1, paragraph C, delete and insert the following new clause. 1 chief nominated by the Regional House of Chiefs of the region. I so move.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 44 is ordered to stand part of the bill. Now, honourable members, I'll put a question to clause 44 as variously amended in the absence of any further amendment. Yes, Honourable Baba Jamal.
Mr. Speaker, I'm looking at XXV, where the amendment that we adopted is a lawyer with not less than 7 years standing as a lawyer nominated by organizations of lawyers. Mr. Speaker,
Honorable Baba Jama, we are in a learning curve.
yes,
At the consideration stage, when a question is put
yes,
on an amendment
yes.
and the amendment is carried, you can only propose a further amendment upon the leave of the speaker.
Mr. Speaker, that is exactly what I'm trying to do. To seek your leave to reconsider that position.
Very well, you may go ahead.
So, Mr. Speaker, I'm saying that if by organizations of lawyers, if we say organizations of lawyers, what do we mean by organizations of lawyers? Should we say it's organization by an organization of lawyers, so that we are specific on it, by an organization of lawyers? But if you say organizations of lawyers, how does it define it? But if you say, yes, but when you say organizations of lawyers, we have different organizations of lawyers. So, but we are not yet in a situation where we have an umbrella for all organizations of lawyers in Ghana. We don't have that umbrella of organizations in Ghana.
Honorable Members, it's a legitimate issue that he's raising, so let's listen to him.
Yes, so because now we have a situation where we have the Ghana GBA, and now we have the Society of Lawyers and other organizations. So if we can say...
Is it the Law Society of Ghana or Society of
Law
Lawyers?
Society of Ghana.
So pronounce it well, Ghana Bar Association
Ghana Bar Association
and
and Society of Lawyers. Mr. Speaker, what I'm trying to draw attention is that if we make it this way, if the rendition is this way, standing as a lawyer,
I think we get your point. Chairman of the committee, what do you say to it?
Nominated by...
In other words, Attorney General, what do you say to this? What do you say to the expression that he's indicating?
Mr. Chairman,
so now we have two organizations.
Yes.
Which one will do the nomination?
Mr. Speaker, in legislative drafting, the singular includes the plural. So there's no need to add organizations to it. I think there was some debate within the committee with respect to whether we could use the language or the expression association of lawyers, because of the fact that it might imply that this is a reference to the GBA or the Ghana Bar Association, instead of a generic reference to the Association of Lawyers in the region. So that is why the committee proposed instead to use organization of lawyers. But I do agree that instead of organizations of lawyers, we should be using one, like an organization of lawyers.
Very well. So you are proposing that we delete the S?
That is so, Mr. Speaker.
Or we delete the organizations and then replace it with
Mr.
organizations?
Speaker, you and the chairman, you are both Cavendish-trained legislative drafting
You are
experts.
also part of the Cavendish-trained legislative drafters. We went to the school together with you. So the proposal is to delete organizations and insert organization. Yes, Chairman. Chairman.
It's working now. It's working now.
Okay. Mr. Speaker, the intendment is to choose one lawyer, whether there are 10 organizations or not. However, they come together to get a lawyer to represent. And so the reason we use a plural, even though we're mindful of the drafting, the Cavendish training you and I attended, Mr. Speaker. And so Mr. Ward-Brew has an association. I don't know whether it's dead or it's still around. plus the other one, Mr. Speaker. And there's a newly created association which we belong, Mr. Speaker. Proudly.
I understand all those things, but the question is that from which association will do the nomination? Because there are two now.
Yes.
If the nominating authority, for instance, is Attorney General, we don't have a problem. We can only say that a lawyer with not less than 7 years standing as a lawyer, nominated by the Attorney General. But this one, you say should be nominated by a body, and we have two. Which one will do the nomination? That is the issue being raised by Baba Jamal.
Yes.
Baba Jamal, is that not the issue?
Yeah, that's the issue.
Yes.
So it is either, Mr. Speaker, if I propose, it's either we make it an organization of lawyers, or we take that confusion away, because it's likely that there can be even another organization of lawyers.
Yes, if you make it organization of lawyers.
That's right.
Which organization are we going to expect
so we can give it
to
to
do the nomination?
So we can give
So
it to
there
the
is some
Attorney General to
uncertainty
nominate.
there. Yes, Honorable Sosu, let me hear you.
Mr. Speaker, I just wanted to draw your attention to the fact that we don't just have two, because we also have Lawyers in Search of Democracy, which is also an association of lawyers. So I think that to avoid the confusion, we can...
And it's likely we will have lawyers who doesn't belong to any of the associations.
Exactly.
In line with the principle established by the Supreme Court
Association.
In the case of Ward Brew versus Ghana Bar Association.
Exactly. So I think we can reserve that to the Attorney General, so that we don't get involved into, which association a rep. So you still want a rep from an association.
Yes.
Yes. So it means you can be in any of the association and be nominated to the yes.
Yes, Chairman of the committee.
Speaker, the intendment is that we want one person. We want one person, one representative.
Yes, the question, we agree on the intendment.
Yes.
Now, the issue that we have to address, and we need your help, is that we have so many associations. Maybe tomorrow I'll be forming one. Which of the association will do the nomination?
Mr. Speaker, the intendment is that those associations will come together and nominate.
Don't you see a difficulty there?
Will come together.
Please,
and
please,
nominate.
please, please. Yes, Honorable James Akarga.
So, Mr. Speaker, in order to cure the mischief ably identified by my brother Baba Jamal, let us further amend the word association to associations, and further amend to read as follows. So if you have associations, then they will do the nomination on a rotational basis, so that in a given year, if Ghana Law Society is called upon to do the nomination, subsequently, the lot would fall on GBA to nominate. That is the only way to cure the problem. The problem. So let's have association.
Honorable members, with all due respect, the Attorney General, at every point, is a leader of the bar, whether the Law Society, whether the Ghana Bar, or whether Ahia Force Lawyer Society. The leader at all those places is the Attorney General. So I propose that the rendition should be a lawyer with not less than 7 years standing as a lawyer nominated by the Attorney General. Yes?
Yeah. Okay. No.
Mr. Speaker, the committee is supposed to represent interest groups. This is the policy underpinning. It is a committee that represents interest groups. The committee is also, I believe, at the regional level. So the idea is that the committee is composed of representatives of the Attorney General, of the Human Rights Commission, and of lawyers practicing in the region. That is the idea. Lawyers practicing in the region. Lawyers in good standing practicing in the region. That's the objective. So you have lawyers, you have the Human Rights Commission, and you have the AG's office. They constitute the oversight committee. The oversight committee is established at the regional level. Yes, the oversight committee is established at the regional level. So in each region, you want the committee to represent the AG, the Human Rights Commission, and then lawyers in good standing practicing in the region. That is what the objective is. So lawyers in good standing practicing in the region will then develop a convention by which they meet to choose their representative. So that it's not done on the basis of associations, but on the basis of lawyers who have registered and are practicing in the region. Yes, they belong to different associations, but we don't want to be enacting associations. We don't want to be enacting associations. In fact, the whole idea is to move away from the enactment of associations. So you don't say Ghana Bar Association. Then you have Progressive Lawyer Association coming to take you on and challenging and going to court and saying that the legislation is discriminatory because it recognizes one association to the exclusion of another association. So the idea is to have representatives of lawyers in the region. So let's craft it so that the rendition captures the intent that the tribunal is a three-legged entity, one leg representing Human Rights Commission in the region, one leg representing AG's office in the region, and one leg representing lawyers practicing in the region, lawyers of good standing practicing in the region. So let's find a way of crafting it to reflect that.
So your argument is sound, but it appears impracticable. Impracticable in the sense that we agree that the lawyer 7 years standing at the bar should be appointed from the region. But who nominates that person? That is what we are talking about. So if you don't want the Attorney General, let's come out with a proposal that leads to how those lawyers are nominated from the region. Yes, Majority Leader.
See, when you say association or organization of lawyers, how about if in the region they don't have an organization of lawyers? You see, but you will have lawyers practicing in the region. And what I believe will happen if we enact that lawyers practicing in the region, a convention will evolve where lawyers who know they practice in the region will convene themselves to nominate somebody. Otherwise, then let's go to the old rendition where there is an association that everybody knows as an association of lawyers, and then say that they should nominate.
Majority Leader, that will be vague. That will be vague. We need to give the power to nominate
Mr. Speaker.
To an entity.
Mr. Speaker.
Yes. Let me hear James Agalga.
So, Mr. Speaker, I can understand when the majority leader says we should not legislate on organizations. But the truth of the matter is that the Constitution itself allows for freedom of association. So that is a right which is already enshrined. And therefore, like it or not, the existence of organizations is something the Constitution already recognizes. And that is why I am saying that the real problem here is which of the associations. Now we are allowed to have a multiplicity of associations, bar associations. That is why we now have Ghana Law Society, Ghana Bar Association, and World Bruce Association of Lawyers. So how do you legislate to ensure that none of those associations or organizations enjoys a monopoly when it comes to the question of nominating lawyers for purposes of appointment? And that is why I propose that let us allow the organizations with S, the plural, to stand.
So,
and then,
in that case, for the
Speaker,
purposes of being nominated, you are compelled to belong to an association.
Well, Mr. Speaker, in this country, practically, do we have lawyers who don't belong to?
If you read the principle established in the case of World Brew versus Ghana Bar Association, the Supreme Court says the Constitution guarantees freedom of association.
Yes.
So membership is not compulsory. So you can be a lawyer and decide not to belong to any association. Because the Constitution guarantees freedom of association.
Yes.
So if we adopt your rendition, it means that for you to qualify, you must belong to an association.
Mr. Speaker, practically, we have had Ghana Bar Association all this while. Mr. Speaker, most legislations clothes the Bar Association with the power to nominate. Have we ever had a situation whereby somebody who is not a member of the association found it necessary to raise questions about
yes, if you look at the history
of the Bar Association?
If you look at the history of it,
yes,
until recently, the only association is the Ghana Bar Association. And there is a compulsory nature of it until the matter has been taken to the Supreme Court. That's why so many associations are now coming. So the monopoly is broken. At first, it's as if you can't call yourself a lawyer until you belong to the bar. That is why we normally say, like this one would have said, good standing at the bar.
Mr. Speaker, look here.
Yes.
Mr. Speaker, because our colleagues have left the chamber, you are minded not to be looking at this place. You don't expect them to be here, but please, I'll urge you to be looking at this side small. Mr. Speaker, you made a proposal.
Well, let me advise you. The rules allow that when we are at the consideration stage, you can move from wherever you are sitting to group.
Okay, so that I can get closer.
But, yes, but apart from the consideration stage of a bill, you must get up on your feet and catch the eye of the speaker to speak.
That's right.
The only dispensation granted by the rules is at the consideration stage of a bill.
Yes.
So normally what happens is you move to an area where people who do advocacy in favor are. So next time I will advise you to do that.
I will take a clue from that. Mr. Speaker, you made a proposal which got very close to resolving this matter. To avoid this confusion about associations and organizations, and taking into consideration the fact that Attorney General itself will be maybe represented on the committee, can we look at it from this aspect? The nomination will come from the Attorney General, all right, but it should be from the private sector. So we can have a private legal practitioner nominated by the Attorney General. So even when Attorney General is represented, you have a private legal practitioner represented, so that we don't run into the problem of these associations. Because as for the associations, once the gate is open, more associations will come in. So I want a rendition, as you know, nominated by that a private legal practitioner nominated by.
No, that in our context, if you are talking about a private legal practitioner, a corporate lawyer in Baba Jamal and Co. Is he also qualified to be a private legal practitioner?
Maybe I will use a different phrase. Instead of the private legal practitioner, maybe we see from the private sector or something. But whatever I'm saying is that it should be a private legal practitioner nominated by the Attorney General. So we avoid this problem of these associations. And so we make it specific. So the Attorney General can nominate any private legal practitioner practicing in the region or in the whatever at any point. So it should be a private legal practitioner, a private lawyer, a lawyer who is not working in government or whatever. It should be a private legal. If we do it that way, we'll get it specific.
Yes, Chairman of the committee.
Mr. Speaker, I think we have flogged this clause for some time now. My suggestion is that once it is a regional oversight committee, we should give that power to nominate to the supervising high court judge in the region. The supervising high court judge in the region to nominate a lawyer with not less than 7 years standing. That's it. And so we can leave out the association. So a lawyer may belong to association or not. And so that this excludes lawyers who don't belong to any of these associations.
Yes, the proposal is that we give that function to the judiciary to perform.
For the supervising high court judge in the region.
Chairman of the, yes, majority leader.
Mr. Speaker, we say that there are issues with the traditional court system. We are creating a tribunal. Then we'll go and say that the High Court judge, who is of the same qualification as the chairman of the tribunal, he should appoint somebody to supervise the chairman of the tribunal. How can we do that? How can we do that? How can we say that the High Court judge should appoint somebody? Yes, that's what we're saying. He should nominate a lawyer to serve on the oversight committee that is oversighting the tribunal in the region. And you are saying that the High Court judge, supervising High Court judge in that region, should be the one appointing a lawyer to supervise the tribunal chairman. So we can say the Chief Justice, but not the supervising High Court judge in that region, because he is of the same stature as the tribunal chairman. Their qualifications are the same. So why should he be the one appointing a supervising, committee member?
So, honourable members, we defer the clause because the qualification of the chairman of the tribunal is equivalent to that of the High Court. You are going to appoint a lawyer 7 years to supervise? Yes, to serve on that particular committee. How we owe fidelity to seniority at the bar? Yes, Attorney General.
Mr. Speaker, this is a committee And the committee can benefit from the wisdom of the legal practitioners. And it doesn't matter that the legal practitioner is
2 years.
No, we are saying 7 years, because under Act 32, that is the point at which you are allowed to practice on your own. So a person like that can serve on the committee. And it's an oversight committee that is more or less monitoring and evaluating the work of the tribunals. You know, at the Legal Profession Act. So
yes, it's just like asking Shaibu to evaluate and supervise your work.
Mr. Speaker, pardon me.
It's just like asking Shaibu, as a lawyer, to evaluate and supervise your work as Attorney General.
Well, no, Mr. Speaker, I think the collective wisdom of the committee is what we are driving at.
Very well.
Not necessarily the individual members of the committee.
Very well.
And remember that we have the Commission on Human Rights and Administrative Justice on it. Okay, and we have a representative from the Judicial Council nominated by the Chief Justice.
So who does the nomination? Yes, let me hear from Honorable Bid Asidi. I want Azuma.
Mr. Speaker, if you look at the membership of the committee, they are nominated by bodies or institutions. So in the case of the Judicial Council, the Chief Justice nominates somebody from that place. The Commission on Human Rights and Administrative Justice, the Commissioner nominates. There is a representative to be nominated by the Regional House of Chiefs or the National House of Chiefs. And also, the Chief Justice will have to nominate 2 persons, at least one of whom is a woman. So the Chief Justice has been given the opportunity to nominate people from the Judicial Council and at the same time from the public. So I don't find anything wrong if we give that authority to the Chief Justice to nominate any lawyer from the region. So then we have solved the problem of having to ask the various associations to come together to nominate. The Chief Justice takes that responsibility and exercises it. And then he just picks a lawyer from the region, and then the lawyer will be part of the oversight committee. So, Mr. Speaker, that is my proposal.
Very well. It's for the consideration of the House. Yes.
Mr. Speaker, when you look at what we are talking here, we are looking for a lawyer who is maybe practicing lawyer. The Attorney General is the leader of the bar. It is a lawyer we are looking for. Attorney General is the leader of the bar. So if Attorney General is the leader of the bar, and we want a lawyer, who will be the best to select somebody to represent? That's why we are, and from the bodies that have been selected, the only people who are not represented is the private lawyers, is those who are practicing. So can't we say that the Attorney General will nominate a private lawyer to represent on the committee, so that the lawyers who practice in the region will have a representative on the committee, nominated by the leader of the bar. So he should nominate. Yeah, the leader of the bar should nominate. So I think that if we do it, now I move that the rendition should be this, Mr. Speaker. I think it should be a private lawyer with not less than 7 years standing. A lawyer with not less than 7 years standing as a lawyer, nominated by the Attorney General. Simple. The Attorney General will look through
Yes,
the lawyers.
Honorable Chairman.
Yes.
Mr. Speaker, I am minded to support this.
I've made this amendment long ago.
Yes.
I'll put a question.
Back to your amendment. AG.
Yes.
Hey, James.
That my colleague Baba Jamal used the word private.
Please,
yes.
please,
Oh,
please,
you've
please,
taken
please,
it out.
Please.
Very well.
He took
I
it
thought I
out.
heard it, yes.
No, he took it out. As many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is carried. Now I'll put a question on entire clause 44 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 44 as variously amended is ordered to stand part of the bill. Clause 45.
Functions of the committee.
Chairman of the committee.
Mr. Speaker, no advertised amendments. No advertised amendments.
It is for the consideration of the House. All members, any proposed amendment to clause 45? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 45 is ordered to stand part of the bill. Clause 46.
Tenure of office of members of the committee.
Chairman of the committee.
Mr. Speaker, I think I jotted something small on 46.
We are not interested in what you jotted. Just tell us the amendment.
Mr. Speaker, 46(5), line 3, after inability, insert of the member.
Very well. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Any further amendment to clause 46? I'll put a question on entire clause 46 as amended. Those in favor say aye. Those against say no. The ayes have it. Clause 46 as amended is ordered to stand part of the bill. Clause 47.
Meetings of the committee.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. All members, any proposed amendment to clause 47? In the absence of any proposed amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. Clause 47 is ordered to stand part of the bill. Clause 48.
Disclosure of interest.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 48. As many as are in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 48 is ordered to stand part of the bill. Clause 50.
Supervision of tribunals.
Chairman of the committee.
Mr. Speaker, no advertised amendment.
It is for the consideration of the House. Any proposed amendment to clause 50? In the absence of any proposed amendment, I'll put a question. As many as are in favor of clause 50 standing part of the bill say aye. Those against say no. The ayes have it. Clause 50 is ordered to stand part of the bill. Clause 51.
Annual reports.
Chairman of the committee.
Mr. Speaker, clause 51, amendment proposed, subclause 1, line 3, after the insert committee and. I so move, Mr. Speaker.
All members, the proposed amendment is for your consideration. Any further amendments? In the absence of any further amendment, I'll put a question. Those in favor of clause 51, those in favor of clause 51 standing part of the bill say aye. Those against say no. The ayes have it. Clause 51 is ordered to stand. Clause 51 as amended is ordered to stand part of the bill. Clause 52.
Record keeping.
Chairman of the committee.
Mr. Speaker, clause 52, amendment proposed, subclause 1, line 2, delete audio and insert electronic.
The proposed amendment is for the consideration of the House. Any further amendment? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now, I'll put a question on entire clause 52. Those in favor say aye. Those against say no. The ayes have it. Clause 52, as amended, is ordered to stand part of the bill. Clause 53.
Ethics and integrity.
Chairman of the committee. Chairman, clause 53. Please, who is putting the microphone on?
Speaker,
Yes.
no advertise amendment.
You are sitting down, you are not even voting, you are complaining of being tired. There is no advertised amendment to clause 53. I will therefore put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 53 is ordered to stand part of the bill. Clause 54.
Immunity of chairman and members of tribunal.
Chairman of the committee.
Speaker, no advertise amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 54? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 54 is ordered to stand part of the bill. Clause 55.
Modification of enactment.
Chairman of the committee.
Speaker, no advertise amendment.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 55? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. Honourable members, the ayes have it. Clause 55 is ordered to stand part of the bill. Clause 66.
Regulations.
Speaker, 5-6.
Chairman of the committee. No, I said 56.
Clause 5-6.
Yes. 56.
The Speaker, amendment proposed, subclause 1, line 1, delete Chief Justice may and insert Minister shall within 12 months after the coming into force of this act. I so move, Mr. Speaker.
Our members, the proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment to clause 56 is ordered to stand part of the bill. Now I'll put a question on entire clause 56. As many as are in favor say aye. Those against say no. The ayes have it. Clause 56 as amended is ordered to stand part of the bill. Clause 57.
Interpretation.
Chairman of the committee.
Speaker, amendment proposed after interpretation for Judicial Council, insert the following new definition. Minister means the minister, the Attorney General and Minister for Justice. I so move, Mr. Speaker.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now I'll put a question on the entire clause 57. In the absence of any further amendment, those in favor say aye. Those against say no. The ayes have it. Clause 57 is ordered to stand part of the bill. Honourable members, clause 58.
Consequential amendment.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? In the absence of any proposed amendment, I'll put a question on clause 58. Those in favor say aye. Those against say no. The ayes have it. Clause 58 is ordered to stand part of the bill. Clause 59.
Savings.
Chairman of the committee.
Speaker, no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put a question. As many as are in favor say aye. Those against say no. Honourable members, clause 59 is ordered to stand part of the bill. The schedule.
Timelines for determination of a case under the Minerals and Mining Act 2006 at 703.
Chairman of the committee.
Mr. Speaker, schedule, proposed amendment, delete. I so move, Mr. Speaker.
So I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. All members, the ayes have it. The schedule in the bill is accordingly ordered to be deleted. All members, we come to the long title.
An act to provide for the establishment, jurisdiction, composition, and operation of tribunals in accordance with the Constitution, establish the Tribunal Oversight Committee, and for related matters.
Yes.
Mr. Speaker, may I crave your indulgence and seek your permission to take us back to clause 25.
To
page 17, clause 25.
Very well, leave
paper,
it.
of the other paper. Yeah. Mr. Speaker, we propose a new rendition for 25, that's inserting the new sub-clause. We propose that the tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. This is a new rendition we want to replace.
So are you deleting and inserting this?
Yes. So we're deleting.
You are making it as an additional clause.
And inserting this. Did we? Yeah.
You see, Honorable Shaibu.
Yes.
As a man, you have to speak for your vocal cord to vibrate. You speak for your vocal cord to vibrate.
Speaker, very well.
So the question therefore is, are you proposing?
Yes, I am.
That
we delete
the entire clause 25, as in 1 and 2,
yes,
be deleted.
Yes.
And in place?
In place of it, we have the following rendition.
Yes.
The tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. I so move.
AG, what do you say to this amendment?
Mr. Speaker, I agree with the chairman's amendment.
Very well, I'll put a question. Those in favor say aye. Yes. You see, that's why I ask, are you deleting 25 as in 1 and 2? The drafter is saying that 25.1 is staying. It is 25.2 that they are recrafting. Because the 25.1 is cross-referencing the very procedure in the Criminal and Other Offences Act. So what do you say? So your proposed amendment is delete clause 25(2) and replace with a new rendition. Do you want to come as second consideration?
Yeah. So, Mr. Speaker, may I just go over it again?
Leader.
24, the new subclause has two components. We are maintaining the first component. It's the second component that we are deleting and replacing it with the new rendition.
Yes, but that wasn't what you said initially.
Very well.
That was not what I was going to put a question on. So, honourable members, for the record, the proposal is to delete 25(2).
25(2).
And substitute it with the new rendition as read by the chairman. The proposal is to, yes, and we have not taken this amendment. We've taken this amendment. We have taken this amendment. Yes. So it's a session. Yes. So is this what they have done? So, honourable members, the amendment actually is not to delete clause 25. He said after subclause 1, insert the following new clauses. So it's an insertion after subclause 1, as in page 17. And page 17 is in twofold. 1, the Evidence Act 1975, NRCD 323, applies to the proceedings of the tribunal. 2, an order issued by the tribunal shall ensure compliance with rules of procedure and guarantee a fair trial. So in this case, it is the insertion that you are further amending in 2. Is that it?
So Mr. Speaker, in 2, we are just deleting the 2 and inserting the new rendition.
Very well.
Yes. So we are taking away an order issued by the tribunal, the whole of the...
Honourable members, the chairman is not speaking loud, and you are also speaking.
Mr. Speaker, the 25 has 2 components, 1 and 2. We are not touching 1. We are replacing 2 with this new rendition. And may I go over it again?
Yes.
The tribunal shall ensure that an order issued complies with the rules of procedure and guarantees a fair trial. I so move, Mr. Speaker.
Very well. Honourable members, the proposal is to further amend the proposed amendment at page 17 of today's order paper to insert. Yes.
Mr. Speaker, my understanding is that first he is adding 2 new subclauses.
Yes.
Then, if he does that, subclause 2 now becomes subclause 4.
No, you leave that for the drafters.
Yeah, I'm coming. So what he's trying to amend is the existing subclause 2. Not replace his amendment, no. The existing subclause 2 is what he seeks to delete and then prefer a new rendition.
Chairman, is that the case? If that is the case, why are you drawing our attention to clause 17? Yes, so leader, there are amendments to clause 25, as in page 17, which amendment has been carried by the House. And this amendment is the insertion after subclause 1. 2 provisions which are inserted, so the numbering will change. Now, what the chairman is seeking to do is to further amend his proposed amendment that has been carried in the second part. Just leave the renumbering for the drafters. So it is not the original 2 that chairman is amending. Chairman, is that the case?
Yes, we're further amending, yes, because it says an order issued by the tribunal shall ensure. It's not the order that shall ensure, but the tribunal, yes. So it is a tribunal that will ensure. That is why we are changing that.
So I'll put a question. Those in favor say aye. Those against say no. Honourable members, the proposed amendment to the chairman's amendment in page 17 of the order paper for today is ordered to stand part of the bill. Honourable members, since it has got to do with clause 25, I must put a question on the entire clause 25 again. Those in favor say aye. Those against say no. The ayes have it. Clause 25 as variously amended, including the further amendment, is ordered to stand part of the bill. Now, the long title has been read. Any proposed amendment to the long title? Or it has not been read? Yes.
Speaker, it's been read.
What is the amendment?
No, the long title has been read.
You said, is there any amendment to the long title?
No proposed amendment to the Speaker.
Honourable members, in the absence of any proposed amendment to the long title, I'll put a question. Those in favor of the long title standing part of the bill say aye. Those against say no. Honourable members, yes, the Attorney General. Honourable members, the ayes have it. The long title is ordered to stand part of the bill. And honourable members, this brings us to the end of the consideration stage of the Tribunal Bill 2026. Yes, Majority Leader. Any more business?
Mr. Speaker, Mr. Speaker, you've taken we are finished with consideration stage.
Yes.
Yes, so Mr. Speaker, we want to take item number 28.
Honourable members, let me take 2 minutes of suspension. I know. That's what I sent the message to him. Yes, Majority Leader.
No, Mr. Speaker, there are 2 minutes suspension. It's appropriate.
Very well. The House is suspended for 2 minutes.